This is our next installment of our Frontlines of Gender Justice series, and I am just so honored to have Farah Diaz-Tello join us to talk about the work that she's doing at If, When, How. You know, we have a student chapter of If, When, How at Columbia, at I think most law schools, and I'm hoping that a few maybe of the students who are part of our If, When, How chapter join us, and some of you in this class may also be members. So Farah is the Associate Legal and Policy Director there at If, When, How, and we'll talk a little bit about what that entails, but was also at the National Advocates for Pregnant Women before joining If, When, How, which is also a wonderful organization that does incredibly important work, focused mostly on the criminalization of pregnancy, but not only, but that's a lot of where their work is. So Farah, welcome. It's great to have you with us. Yeah. Do you want to jump into a short presentation, or do you want, how would you like to structure our conversation?
Yeah, let's go through the presentation first. I have a bit of like a level setting presentation that I prepared for y'all so that we can have some common terminology as we move into it, and then we can just have a conversation from there.
Good.
So I'm going to attempt to share my screen. It's always a little bit dicey. Okay, do you see my slides?
Yep, looks good.
Terrific. Okay, so I am so grateful for the opportunity to spend this time with you today, and I'm looking forward to fielding all of your questions. I'm going to kind of plow through all of this, and then we can have questions at the end. But so I want to center this conversation in the fact that with all the recent changes to the Supreme Court, which are these changes are going to be with us for a while. The question on the minds of a lot of advocates for reproductive rights, health, and justice is what a post-Roe future is going to look like. And so, you know, from a reproductive justice perspective, by now it's almost a cliche to acknowledge the fact that there are many communities for whom Roe was never a meaningful reality, and that the legal right to seek an abortion never materialized into true self-determination over people's reproductive lives. Now, that doesn't mean that Roe is entirely insignificant. It provides a basis from which we've developed a legalized and formalized system of abortion care. And as Joanna Erdman once observed, there was no such thing as a back alley until there was such a thing as a front office. So what we're going to do, we're going to spend the next few minutes just discussing some of these areas where the legalized system for abortion doesn't reach, right? Like the creation of institutions by definition creates interstices and spaces between the institutions where the law doesn't necessarily reach. So we're going to move out of the penumbras and just directly into the shadows between the laws, and how we work to support the people whose reproductive decisions exist really beyond Roe. First, a little bit about us. So you may know us as an on-campus organization, or may have heard of previous incarnations of Law Students for Reproductive Justice, or even before that, Law Students for Choice. And now we've graduated, and we organize law students, lawyers, and other activists, as well as we do what I like to call impactful litigation, policy advocacy, and provide legal advice, all to ensure that everyone has the rights and resources to determine if, when, and how to carry a pregnancy to term and create a family. And our strategic initiatives, the one that brings me here today, is work to halt the criminalization of people who end their own pregnancies. To get back to where we were, we're going to talk a little bit about what we mean when we say self-managed abortion. So when I say self-managed abortion, what I mean is any self-sourced means that a person might use to end a pregnancy on their own, either alone or with support, that's outside of the formal medical system. And so this is distinct from telemedicine abortion, which involves a clinician who's actually prescribing the medication. Now, historically, this has included ingestion of substances such as herbal remedies, foods, or other beverages. So we're talking about any means that a person might use to end a pregnancy. And so some of these are safer, some of these are less safe, and you know, some of them even have the potential to cause injury or harm. But all of these means are within the umbrella of what we mean when we're talking about self-managed abortion. So fortunately, advancements in reproductive health technology have made self-managed abortion safer than it's ever been in the past. So self-managed abortion really looks more like the other ways that people manage their own healthcare needs using the internet and offshore pharmacy when healthcare is inaccessible for a variety of reasons. And, you know, one exception is that some groups are facilitating access using other creative strategies like this drone that you see here, which was flown from Germany, where abortion is legal, to Poland, where abortion is prohibited, not as necessarily a means of providing abortion care to everybody who needs it, but rather showing the hypocrisy of the fact that a border will dictate whether or not people are able to access reproductive health care. But I want to be clear that our position that nobody should be punished for ending a pregnancy isn't predicated on the use of pills. And in fact, some of the histories of resistance to the medicalization of abortion, like the Jane Collective and the Feminist Women's Health Center self-help groups, used safe abortion techniques, including suction, and you can see here a device that women invented themselves from household equipment, and even using curettage without formal medical training. So when we say nobody should go to jail, we mean nobody ever, regardless of how they ended their pregnancy. Our aim in this work is to ensure that everyone has access to abortion care that meets their needs and affirms their dignity. And it's important to keep in foremost view that real people have real reasons for seeking self-managed abortion. They always have, and they always will. And it's our response to it as a society that makes all the difference. So, you know, we like to think about push factors and pull factors. So some people may find themselves pushed away from the formal healthcare system by barriers like waiting periods that make them break their procedure over the course of several appointments, geographic distance, or even the harassment that they encounter when they arrive at clinics. Other people find themselves pulled towards self-managed care by a desire for a more private experience, or to be surrounded by people of their choosing, or to even to incorporate religious or spiritual practices into their abortion. And it turns out that this is borne out by research as well. Research conducted by Abigail Aiken at the University of Texas's Project SANA asked people in the US who were seeking abortion pills through an online service why they were trying to access self-managed abortion. And the research showed that the majority of people had a mix of reasons. Cost being the most frequently cited, and as we know, cost isn't something that exists in a vacuum that's set by the abortion providers themselves, but often is reflective of the restrictions placed on abortion provision by lawmakers that end up being passed on to recipients of that care because for example, in my home state of Texas, the requirements for the widths of hallways or HVAC units and all that make it more expensive to provide abortion care. So people had other reasons as well, including privacy of the home environment or the need to keep their abortion a secret, either from family members, an abuser, or somebody else. So the million-dollar question, right? The one that I get asked most often, and the one that the SIA Legal Team was founded to try to answer. What's the legal status of self-managed abortion? It turns out the answer is quite complicated. And to figure out the answer, we really have to dig into a much bigger question, and one that in some ways is more philosophical than a strictly legal question. And that question is, what is an illegal abortion? What is it, and where did we even get this concept? And so it turns out that the concept of an illegal abortion came to us courtesy of the American Medical Association. This print depicts its founding. I like to call it a portrait of fossils and a mastodon. And the first anti-abortion laws came at the behest of the nascent medical profession seeking to exercise control over healthcare practice. So prior to the professionalization of medicine, the healing arts were practiced by a variety of different people with a variety of different types of training, ranging from charlatans and bloodletters to people whose ministrations actually helped. And as they organized under the banner of physician, the one area of healthcare that was open to providing an unlimited market was reproductive healthcare. Historically, the wisdom of how to birth babies and prevent pregnancies and restore menses was considered "quote unquote" women's business, and midwives, herbalists, and other community healers tended to the reproductive health needs of their communities. So these include Indigenous midwives who've been practicing long since before the ground that we stand on was called the United States, and the enslaved African midwives who were brought to the United States through the transatlantic slave trade and provided healthcare services to their own communities as well as to the white women to whom they were enslaved in the U.S. South. Immigrant midwives who tended to communities in the tenements of the industrialized Northeast, and even as far back as the women who were burned as witches in the colonial days. And so, because these were the people who were providing this healthcare to people who weren't even considered persons under the law, this meant that the law generally didn't have a lot to say about ending pregnancies. So it wouldn't have been uncommon to see advertisements for medications for women's ailments in the penny press, or for people to visit a local midwife to bring down the flowers or to unblock a menstrual obstruction, all of these sort of coded language for abortion in those days. The nascent medical profession claimed superior knowledge of the fetus and portrayed midwives and other healers as being dirty and backward in racist campaigns, and urged the passage of laws controlling abortion. And the passage of criminal laws turned these practitioners into criminals overnight, essentially, especially when they made a living from their work, as did who you see here, Madame Restel, or Anne Tro Lohman, who was a midwife and patent medicine seller here in New York City, who became a target of the AMA and other moral crusaders. And this moral crusade ultimately led to the criminalization of abortion in New York, which really wasn't fully undone until 2019. Fortunately, the medical profession has come a long way, and you can see these are some of the physician groups that have spoken out specifically to denounce the criminalization of people who end their own pregnancies. So to answer the question that we set out, historically, an illegal abortion is something that one person does to another person, not something that a person does to their own body. Now, that being said, people have been criminalized and even spent significant time in prison for having ended their own pregnancies, and prosecutors have used a variety of different types of laws to accomplish this. First, we have the states with criminal laws that specifically prohibit self-managed abortion. And so fortunately, you can see here on this map, there have been some recent changes, and we're hoping that there are some changes still to come on the horizon. So New York repealing its law prohibiting self-managed abortion in 2019 with the passage of the Reproductive Health Act. And in Idaho, their law, while it's still on the books, was held unconstitutional in 2012. So, we like to hope that it is unenforceable, even though it's currently still on the books. But when we talk about like what's pre-Roe, post-Roe, beyond Roe, Roe actually speaks to this in a very limited sense. To note that I think it comes as a surprise to many people that criminalization of people for ending their own pregnancies was always an outlier position, even going back to the common law. And you can see here in this language from Roe, even the Texas criminal abortion statute that was struck down in that case didn't criminalize the individual for ending their own pregnancy. It in fact did contain an exception for the pregnant person. What are more common across the states and were more common throughout history were these laws that made it a crime for an individual to end another person's pregnancy without legal authorization to do so. So in many states, abortion is defined, broadly is defined as a crime, and then legal abortion is an exception to the crime. And that's the setup that we had in New York. That is, there was sort of the crime of abortion, and then a category of justifiable abortion, which was sort of mostly what we think of as legal abortion to this day. And some states have been working to repeal these antiquated laws to ensure that if Roe were to be overturned, that abortion wouldn't be criminalized, or the people who end their own pregnancies wouldn't be criminalized. But unfortunately, a trend that we've seen is prosecutors taking these abortion laws and applying them to people who end their own pregnancies, essentially arguing that a person is their own illegal abortionist. And then finally, we have fetal harm laws, which are really a much newer trend. It's sort of a post or an after Roe trend. And these laws are most often passed in the name of protecting a pregnant person from harm and make it a crime for someone to cause another person to lose a pregnancy. So currently there are 38 states with these laws, feticide laws, unborn victims of violence laws, sort of how they're generally termed. And the majority of these states have some specific provision in them that prevents them from being used against a person who's pregnant in relation to their own fetus. So the states that you see here are the ones that don't have this protective language. In fact, in many of these states, they don't mention the pregnant person at all. And so prosecutors will seize on this silence to argue that if someone else can be charged with a crime for causing a miscarriage, then the pregnant person should be able to be too. So even though it's always been the position in nearly every state in the country that a pregnant person can't be liable for the outcome of their pregnancy, we've also seen an increasing trend in abortion opponents who are working to challenge this, such as this Texas representative who introduced a bill to actually repeal the protections in Texas law that protect pregnant people from being prosecuted for crimes against their own pregnancies. So this would let people be charged with homicide for having an abortion, which he said would make women, I think he said females, which is would make females more personally responsible in the decisions they make around sex. So essentially using the threat of criminal prosecution to try to keep people from having sex and becoming pregnant, which has never, if we look at the history of the criminalization of abortion, has never been a strategy that has worked to prevent abortions. It's certainly never been a strategy that's worked to prevent pregnancy or sex. And then finally, we have a map of states where there have been criminal arrests or investigations of people based on allegations that they did something to end their own pregnancy. And you can see there's actually very little correlation between the laws that I just pointed out and where arrests have actually transpired. And the fact is, the law says a lot of things, but to the never-ending chagrin of good government Leslie Knope types like me, the words often just don't really matter. And once a prosecutor has decided that they want to punish somebody for having an abortion, they're going to figure out a way to do it. The good news is that there has been some positive strides. Even just within the last couple of years, 2 states have included language in their reforms of abortion laws that prohibit the criminalization of abortion and miscarriage. But what took me a long time to understand, I think it was, I was already well into my practice as a lawyer before I understood, is that criminalization isn't about really what the law says, but it's about how society categorizes you. We're now finally reckoning with the fact that what the law says is only just one factor affecting criminalization, and that a person's race, their socioeconomic status, their contact with other state systems are going to determine whether or not they're criminalized. And as it turns out, the most important factor really isn't the law, it's whether a person who presents with a miscarriage or an abortion is met with hostility and stigma, because the stigma itself leads to criminalization. And this was the subject of an amicus brief that we filed in the June medical services case before the Supreme Court last year. And I want to close us out of this, this portion of the presentation by talking a little bit about how we're working to ensure that people don't become ensnared in criminalization because of their reproductive health decisions. We provide direct support to individuals who are criminalized. So we're currently working on criminal cases, 3 criminal cases in 2 states. And we provide legal information to people with questions about their rights and the potential risks that they face in self-managed abortion, as well as providing technical support to community partners so that they can advocate and educate where they are without fear of criminal consequences. And we also work with them to change the law to ensure that nobody has to fear jail time for having an abortion. And this is the most important slide that I'm going to share with you. If you're going to screen cap one thing, this is the one to screen cap. This is the information, the contact information for our Repro Legal Helpline, where people can actually get legal information. We have a very extensive FAQ, and then people can actually contact us through a variety of secure means with questions about criminalization of self-managed abortion. So keep it handy, share it with folks. We're always eager to answer questions. And with that, we can proceed with the rest of our discussion. I'm so glad we made it through the rest of those slides without any white supremacist harassment. Thank you all so much. I'm going to stop the screen share.
Thank you, Farah. That was, again, I apologize for the ugliness of the early part. I think we fixed that problem for now, at least. That sort of stage setting is really helpful for us to understand both the work that you're doing and the political context in which that work is taking place. Those maps, I think, are very helpful. Could you say a little bit about if, when, how? You know, how many folks work there? What, you know, what kind of work do you all do? I know you're doing this SIA work, but you know, what's the mission of the organization, et cetera?
Yeah, I mean, the mission, I think we like to say it's right there in the name. We work to ensure that everybody has the rights and resources to determine if, when, and how to create and sustain families. And our work actually, so we are sort of a bit of a hybrid organization. So my path into the, okay, I think we're currently 24 people, maybe 25, to answer that sort of basic question. But when I started, I actually was at an organization called the SIA Legal Team, which was the Self-Induced Abortion Legal Team. And then we deprecated the acronym. So it was just SIA, like NARAL doesn't stand for anything. It's just the SIA Legal Team. And our work there focused very specifically on helping the criminalization of self-managed abortion. And this was when If, When, How was mostly doing the work of organizing law students and lawyers. And so essentially, you know, what we had was an organization that was working on campuses and with attorneys to mobilize them around reproductive justice, sort of broadly, and then an organization that was doing litigation and policy work in service of reproductive justice that was going to be developing networks to help support the work of the helpline, to help to create a network of criminal defense attorneys to assist in cases where people are criminalized. And so, so we came together, actually, so we, I guess, both merged under the umbrella of If, When, How. And so now, you know, we like to say that we use different modalities of working with law students and lawyers. So that includes organizing the direct support work through the helpline and technical assistance. We do litigation, policy work, and legal research. So that's kind of like the how we do our work. And then the types of work we do, we have some broad issue areas that we refer to as our strategic initiatives, ending the criminalization of self-managed abortion, ensuring youth access to abortion, I guess improving people's access to safe and healthy births, or I guess promoting birth justice. I always start to peter out this way, overturning Harris versus McRae, and there's one more. Oh yes, and repealing welfare family caps. And so, like my own personal work on these things, I focus most specifically on what I like to think of as the portfolio of work for people who are marginalized by healthcare systems, so self-managed abortion and birth justice. But for any of you who follow youth access work or like judicial bypass or parental notification, you may have heard talks by my colleague Jessica Goldberg. So we have kind of a large staff now that has a lot of moving pieces to it. Yeah, and it's exciting having gone from an organization that was basically a startup to now one that addresses a wide range of issues in a variety of different ways over just the course of a couple of years.
It's really incredible. So the term birth justice, we all know reproductive justice as an important term that Loretta Ross and others have advanced, but birth justice may be new to some people. Say a little bit about what that means.
Yeah, so birth justice is essentially, it's a reproductive justice approach to issues in birth, right? So looking even in the time that I've been doing this work, at the beginning of it, there was relatively little attention that was being paid, even like within the reproductive justice movement, to what was happening to people giving birth, to the way that they were treated, and their just even to the ability to survive and thrive through that process. And so I think that we have come around to a realization, led by groups like the Black Mamas Matter Alliance, here in New York, Ancient Song Dual Services, some of our favorites, that these things matter, that we can't have true reproductive justice without ensuring that people have dignified experiences of birth, and that we're not just replicating the focus on abortion that we have seen historically in the reproductive rights movement, but broadening that out to ensure that people who are carrying their pregnancies to term also are treated with respect and dignity. And so what that means, I think, in practice for people who are doing, policy work in this area, is centering the solutions that are presented by people of color, and especially by people who are most affected. So Black women and Indigenous women are the ones who are most affected by the crisis of maternal mortality in our country. So it's important for us to devote resources and to take our lead from the solutions that leaders in those communities are setting out. So, I think we see a lot of very well-intended efforts on the parts of folks who want to do something to help. So like here in New York, for example, there was a proposal to create a state doula certification. So there, you know, I forget exactly which authority would have the ability to sort of provide the credential of New York State certified doula. And I think for some people maybe who were not like super conversant in this, certainly for all the lawmakers, because it's passed unanimously, they were like, oh, doulas, that's great. Like, you know, we want people to have support in birth, wonderful. But like talking to the community-based doula groups, especially in New York City, I said, well, you know, you're creating this credential when we already credential people, so like we already have standards, we, you know, certify doulas. And then you're also saying that people need to pay fees, which is going to be a barrier to people who are working in low-income communities and, you know, working within their own communities, right? Because that's going to be a barrier. And there's also a sort of good moral character requirement. And like, what does it mean to be a good moral character for a doula? And would that exclude people who were formerly incarcerated? Because we know that the experiences of incarcerated folks giving birth, often like they are experiencing some of the most dehumanizing care possible. And so, you know, this would cut off the opportunity for somebody who had been through that themselves to serve within their own communities. So, you know, it was one of those things, it was like thanks, but no thanks. This isn't the solution that we need. You know, there are other types of things. And so we really need to be listening to the folks most affected to know what's actually going to be a useful solution.
Yeah, I really love how you and the organization are not just abortion focused, although that's important, but situate the SIA work within a larger context of reproductive justice, not just in the words you use, but actually the work that you do. That giving birth has a place of prominence as much as terminating a pregnancy. I think that's so important. Could you give us your sense of where the Supreme Court is right now? And you know, every term we have a case or more that looks teed up to either as a challenge to Roe directly or a defense of Roe from our side. So where do you see the landscape right now in terms of where the court is, what cases they've taken and where they're going to go?
Yeah, so in terms of where we are, it's not great. I think it's exactly as anticipated. For folks who are interested in abortion outside of a clinic setting, you know, one of the cases that folks have been following is the Acog versus the Fda case, in which essentially Acog challenged the FDA REMS, or the risk evaluation and mitigation strategy, that controlled how abortion pills are, how they're distributed. So generally the FDA has additional extraordinary and very highly politicized control over abortion pills, such that, you know, typically like before the pandemic, people would actually have to go to a clinic and physically like pick up the pills. In some states, they have to like take the abortion pills in the clinic, or at least take the mifepristone in the clinic and then go home. You know, they still go home and experience the abortion on their own and self-manage the symptoms. And then when the pandemic set in, Acog said, this is not acceptable in the context of a pandemic. You're essentially like forcing people to expose themselves to additional healthcare risks to get medications that like literally all they're having to do really in the clinic is pick them up. And so, so essentially they sought an injunction against the enforcement of the REMS, which permitted an expansion of abortion by telemedicine. So that meant that providers could have a telemedicine visit with a patient and then actually mail them the pills. So people could get abortion pills by mail. And there are sort of other tracks where people are able to get this through studies that are approved by the FDA and all that. But like this meant a big expansion of that. And then just last month, the Supreme Court, this is the first case that they took on, the first case, I think, with Amy Coney Barrett on the court, and essentially the Supreme Court reinstated the restrictions. And, I was talking to folks at the ACLU Reproductive Freedom Project who were the lead counsel, and they were virtually apoplectic because one of the things, the Supreme Court had sort of sent it down and said, we need more evidence as to whether or not the circumstances have changed from when the case was originally filed to now. And if anything, if you're watching the news at all, but the pandemic has gotten worse and worse in more places too than it was at the outset. And the Supreme Court still essentially said that we could reinstate the REMS. And so, I think I think this is the Supreme Court, this is like the time bomb that was laid and is working exactly in the way that it was intended to. And so I think what it's going to mean is that we're going to have to get more creative and use other strategies, use, you know, political and electoral strategies to try to advance rights, as opposed to looking to the federal courts as a source of relief. So, so not wonderful. I think that probably what you're going to see is a lot of litigators trying to stay out of federal court, just because the prognosis isn't wonderful. And, you know, I'm not of the belief that like we're going to get the magic bullet case that's going to overturn Roe. I think that the court is, you know, it's possible that there will be a continued erosion. We'll say I am hopeful for the possibility that there won't be a wholesale overturning of Roe, you know, a reconsideration of whether fetuses are considered persons, which would be devastating, right? Like I think that we're not there, but it's not good. Yeah.
What about state courts? Are there some states where you feel comfortable-ish? By your facial expression, I'll say ish. Litigating a more friendly forum than the federal courts?
Yeah, well, so that's the thing. The majority of our cases, so because we're not, we're working outside of we're kind of in that beyond Roe space. So the majority of our cases are in state courts, right? And in fact, they're in criminal courts. So I think, you know, for us, like the landscape really hasn't changed. We tend to see a lot of hostility, especially like at the lower level. Like, you know, I mean, essentially a lot of the cases that we're working on are like reverse impact litigation, because like if you're doing impact litigation, you want like the perfect case, you want the, you know, the issues cleanly presented before the court, right? There's a lot of sort of like litigation hygiene that's done even before like a case ever comes to a trial. In a situation in which somebody's being criminalized for having ended a pregnancy, none of those luxuries exist. You take the case as it comes and really hope for the best. And I think, you know, as the maps showed, the law really is on the side of the person who's ended their pregnancy in the vast majority of states. So yeah, so that's just to say, like, I think it really depends on the types of cases, and folks who are doing more litigation to kind of widen the pathway to the clinic. I think that there is hope in some states. You know, I mean, there was that good decision out of Kansas, of all places, based on like state constitutions. But that's a little bit beyond the scope of the work that we're doing specifically.
Okay, well, you know, New Mexico also did interesting things interpreting their state equal rights amendment that were, you know, sometime in the 90s, that I thought was also quite wonderful, securing abortion rights reproductive rights under the state constitution. So I'm going to invite Natalie to step in next and ask a few questions of you and the work and the material that we read for today. So Natalie, take it away, please.
Thank you. Thank you so much, Farah, for being here with us and for your very, very powerful insights. We all read your report, your SIA report, and also your piece on obstetric violence, and it was all very, very illuminating. So thank you for that. I have a question about, you know, what would you attribute this over-criminalization of self-abortion to, in your opinion? And, you know, are there deeper reasons that can explain such a criminalization that's just been getting more and more vigorous over the years? Specifically, we are all looking at, you know, factors like racism, political religiosity, and also patriarchy. So, in your view, how do these like systemic structures create such a negative criminalization of abortion today?
I really appreciate that question, and so I think the answer to it is quite nuanced. I think that it is very easy to see the milieu of criminalization of people who end their own pregnancies and think that there's like necessarily a sort of direct causal connection, right? That like these prosecutions are being led by anti-abortion crusaders who have somehow managed to infiltrate prosecutorial systems. And like the truth is actually a lot more complicated. I think that really what we're seeing is the culmination of just sort of a more generalized trend towards using criminalization as a response to a variety of different types of social issues. So I think it's in the cases that I worked on, it's actually been like really the minority of cases where you could point to a clear politicized motive on the part of a prosecutor, other than sort of an over fidelity to the idea of law and order. And so that's where stigma comes in, right? Like, because, you know, because the law doesn't say that it's a crime for a person to end their own pregnancy, somebody somewhere had to get the idea that there was something like bad and wrong in a person ending their own pregnancy. And you certainly wouldn't see it, you know, if you like to talk about, like, if somebody did a home appendectomy, terrible idea, right? Like, very harmful, but you would never fathom criminalizing them. And it's because we just don't have the same sort of social stigma about other sorts of self-managed healthcare. So it's the stigma that sort of like creates the situations where people are then turned over to law enforcement. And then once law enforcement takes over, you know, like to say, if all you have is a hammer, then everything starts to look like a nail. And so, like, one of the cases that we're dealing with right now, you know, it's clear that the person, you know, allegedly ordered pills online and ended a pregnancy. None of these things are against the law, but the prosecutor is just really looking for something because it just feels like there was something wrong. And you know, in fact, in the prosecution of Bebe Shui, who you may have like heard of this case, she attempted suicide, survived, but gave birth to a baby who was born alive and died shortly afterward. And the prosecutor in that case was just insistent. This is not an anti-choice thing. This is not an abortion thing. This is a person did a crime, and we have to address that. And so it was like really almost this like weird lacuna, right, in like the ability to see that like actually this prosecutor, in saying that they're adhering to the law when like no law actually applied, is really enforcing patriarchal norms, is also like enforcing racist tropes. Also, in particular, I think it's notable that in Indiana, you know, the only two people who've been criminally prosecuted for allegedly ending a pregnancy have been women of color, right? So like the sort of the determining factor almost is like who you are and how the people who like receive your story respond to it. And when I say like the people who receive your story, that could be healthcare personnel, right? Because like, you know, healthcare personnel, people, you know, who receive people in emergency rooms, the decisions that they make really make all the difference, right? Like if they decide to just treat somebody, like adhere to their requirements and, you know, uphold patient confidentiality and just treat them, that person isn't going to come to the attention of law enforcement, you know, most likely. But in the majority of the cases of criminalization that we've seen, it's actually been the healthcare providers who turn people over to law enforcement. And then, you know, it's sort of so on down the line. Like there are cases where like even, you know, the healthcare personnel will turn the patient over to child services and child services turns them over to law enforcement. And then, you know, and like law enforcement have a certain amount of discretion. Prosecutors have a certain amount of discretion. They could see the case, you know, as happened in Kenley Jones's case. She used misoprostol and, you know, delivered and she was actually arrested and the sort of, you know, the warrant charge was homicide. And then later on, the prosecutor looked at it and said, there's nothing illegal that happened here, and like had to put out a public statement, right? So we see that discretion on the part of prosecutors to just decide not to prosecute can also make the difference here. So yeah, I think that like the fraught atmosphere and like the intensification of restrictions on abortion sort of in an indirect way create a situation where we see people like we see just abortion generally, whether or not it's self-managed, as being something that's like wrong and thus to be controlled through the criminal system. And that's the weird thing about our system is that, like, you know, we, like I mentioned at the outset, we have this like big formal legalized system, and it could be the case that anything that falls outside of that, you know, is like outside the building, right? Like outside of the four walls of the clinic is just like life. It's just humanity. It's the way that people live their lives. Like there are a lot of decisions that people make about love and sex and family and reproduction that aren't controlled by the law. But that in this weird case, like the sort of abortion exceptionalism means that like our response to the areas that are outside of the four corners is criminalization. And like, that's wild.
Thank you so much. I have another question about what role do you see Roe playing today, if any, in the reproductive justice movement? You mentioned about how, you know, you guys are moving beyond Roe. You're looking at litigation in the state level. So I was wondering, what do you see Roe today for the causes that you're working so hard for?
Yeah, so there's a push and pull, especially among reproductive justice advocates, of wanting to say like, well, Roe doesn't mean anything to anybody anyway. But then like there's sort of the opposite side of the coin where it's like, well, but if Roe were overturned, like the people who like we're centering in the work that we do would be the people who would be most directly and most harshly affected. And you can see, if you follow sort of repro health spaces like Rewire News Group, the kind of like interplay between like Roe doesn't matter, how dare you say Roe doesn't matter, like, and it's one of those things where it's like everybody's right. Roe is significant because it creates this legal framework. The Roe line of cases they are the law, and the law, in many ways like constrains the choices that we make, or it has a material impact on people's lives. And by the same token, it's not the whole story. What the law says or what the jurisprudence says isn't like the sum total of the way that people experience their reproductive lives. So so I guess like it provides a floor, but not a ceiling. But I think also like the reality of self-managed abortion is that like self-managed abortion kind of, is not really spoken to within Roe. And so it provides what I like to think of as a hopeful or a creative space for people to find ways to meet their reproductive needs without without having to sort of like go through is this an undue burden? Is it a substantial fraction? Like what, I think that we would never concede if we were like litigating a case that the Roe and Casey line of cases that like that applies to self-managed abortion. I think that we're completely like in a different world of like decisions that people make about their own bodies, which would be more akin to, just the sort of Washington versus Glucksberg, like Cruzan line of cases that are about like people's intimate decisions about their own bodies, not about specifically like, I mean, the way that I like to put it as a just very crude shorthand is that Roe really speaks to who gets to call themselves an abortion provider and how the state controls the provision of abortion. But when we're not talking about abortion that's like provided by somebody else, that, the questions are much more wide open. So like it matters a lot and it doesn't matter at all at the same time. And that's just the reality.
Natalie, why don't you have one more question and then we'll pass it off to Raymond.
Sure. Farah, you have written in your report that you about a proactive expansion of abortion autonomy rather than a reactive defense against restrictions. And I think you mentioned this in the context of legally guaranteeing the option of abortion, whether in whatever healthcare setting in your home or as in a formal setting. I also saw this as encompassing facilitating like meaningful access in terms of financial and practical support to the different types of abortion methods, as well as healthcare and childcare more generally. But yet with the legal hurdles of criminalization set so high, how do you envision such an all-encompassing yet strategic approach to secure reproductive freedom?
Yeah, I mean, it's a big vision. I think that what I'm seeing in the movement is a recognition that, especially abortion with pills, which is just extremely safe, millions of people around the globe have ended their pregnancies safely using pills, that we can get to a point where abortion becomes sort of too big to fail, right? That like once enough people are able to access abortion through means that are not like what the state has prescribed, it sort of calls the question or really like exposes the fact that the state, this isn't something that the state can completely control. Now, I think that, this is something that we hold with a recognition that it's a bit of a tightrope walk under the current legal system, right? Like what we see is that like the vast majority of people who self-manage their abortion manage to do so without coming to the attention of the medical system, without coming to the attention of the legal system. They're able to get the care that they need safely. But we want to be attentive to the people who sort of fall off of the tightrope and make sure that there is a safety net there, make sure that nobody's ensnared in criminalization. So we want to be very sure that we're not creating sort of a two-tiered system, even within, within our creative solutions, where some people are able to self-manage and other people become criminalized. And so, I mean, I think it's a vision that's evolving, and it's something that that takes more than just lawyers. Also, I mean, I think, not to undersell the importance of the work that lawyers do, but, looking at the ways that communities like take and interpret these messages and educate among their like own local communities, is something that's been really fascinating. And I'm excited to watch it unfold. I see my job as being very much, kind of a plumber, like that we offer a technical skill to assist people who are in trouble, and to try to change the law so that people don't get in trouble. But the larger cultural work, the sort of, making abortion too big to fail, is thankfully outside of the work of nerds like me.
Thank you. Raymond, do you want to pick it up here with a couple of questions?
Yeah, again, thank you so much for your time, and thank you for your presentation. It was excellent. You just mentioned the politicization of a lot of these issues is what's creating a lot of pushback when you try to like guarantee reproductive rights. And specifically in your obstetric violence article, you talk about the politicization of these issues by medical providers is actually was a good indicator of how they would how coercive they would be in seeking a C-section. And so I was wondering what type of work needs to be done to kind of combat that political slant that we see, not even from a DA, but from medical providers themselves.
Yeah, I love that question. So I think maybe what it takes is separating people's maybe their identities from their politics. I don't know. I think what I have in my mind right now is the fact that research consistently shows that the vast majority of people are in support of legal abortion, that people who need abortion should be able to get them. And there's some malleability in the sort of the circumstances and the details and all that. But that generally, when you ask people the question of if somebody you knew needed to have an abortion, would you want them to be able to access it quickly, without coercion and protesters and all that? People overwhelmingly say yes, regardless of their political affiliation. And so I think that it's very easy to get lost in a sort of polarized discussion of pro or anti, our fetuses persons or fetuses not persons, and to lose the nuance of what are the experiences that we really want for people. And I think moving it out of that space to have the question be less what are you in favor of, or which political tribe are you affiliated with, more towards what do you want the world to actually look like. And for sure, there are some people that the world that they want is one in which people who have abortions are locked up and the key is thrown away, but that is a marginal position. That is not a mainstream position, even among conservatives, capital C conservatives. So I think that's one of the beauties of the reproductive justice framework, is that it creates a lot of space, for ambiguity and even I think for discomfort, right? I think opening space for people to have whatever feelings that they have about abortion in their personal lives, but recognizing that the feelings that they have in their personal lives are not necessarily what we should be creating law on, and understanding the material realities of the lives of people. But when you look at for example, the Women's Health case in Texas, right? I think that that was sold to the laws that were passed were sold as being in support of the health of pregnant people. Well, of course we want to do everything we can to assure the people who receive abortions that they're safe. But then when you actually looked at what it meant, and the fact that there was not really any increase to safety, but just meant that people had to take a bus across West Texas to access the next abortion provider, and that frankly just some people weren't able to get abortions that they needed. I think that makes it a lot less politically palatable to hold these positions that are actually harmful when you look at what it means for people's lives. So I don't know, maybe the antidote to politics is just a little bit of reality and listening to people who are harmed by these political choices.
Thank you. Speaking about specifically obstetric violence, in your article, you had these really powerful narratives from women who are essentially fighting against the system through litigation for the violence done to them. I was wondering, how does that framing change when we acknowledge the fact that trans folk can also get pregnant? And so how does we move from a specifically women-focused framework to a more inclusive framework that includes trans folk as well?
Yeah, I mean, I think it's a seamless move, right? I think to me, like, there is nothing that's lost or even necessarily changed in moving from thinking about pregnancy as something that is like coded to women to something that, you know, is just anybody who is capable of pregnancy. And this is something that's like sometimes we have to do like a little bit of walking through in briefs, you know, where we're saying that it is, that it's discrimination on the basis of sex. For instance, like the Renat Dre case, which was raised in that article, we just filed an amicus brief in her sort of most recent volley before the appellate division. And we have to sort of explain to the court, like, how is it possible that this is sex-based discrimination when we're also like acknowledging that people of a variety of genders can become pregnant? And it's like, because the status of being able to become pregnant is itself like that is sort of the category that we're drawing, and that it's not necessarily, they're like, I think folks who are like transmasculine or gender nonconforming aren't like necessarily privileged by that status by fact of being non-cis, right? So they come into the birthing room or like come into these like obstetrical care already like being seen or being categorized as like as other in the same way that like people who identify as women who are pregnant like also are. So I think it's one of those things that maybe like kind of as we get more used to being able to make those arguments, it becomes more organic. But I think that when we're just like talking about it, it's quite easy to see that marginalization on the basis of becoming pregnant is something that like we can like easily and fluently apply it across genders.
I'm going to ask Raymond to ask one more question, and then other folks, please raise your hands because I'd love to spread the love around. So.
Thank you again for that answer. My final question. So you mentioned that women of color, communities of color are affected disproportionately by a lot of this obstetric violence, and also in other areas of reproductive justice. Specifically, actually not necessarily specifically, what additional protections over just let's reform the tort system or let's use federal policy do we need to protect women of color when it comes to obstetric violence?
Yeah, so I think one of the things that folks have been looking at recently is like anti-racism training in like, like from the point of like medical school or nursing school, because especially I think a lot of, especially like neglectful care, but certainly disrespectful care, stems from racism that is like baked into the educational system. You know, the belief that that Black women experience pain differently, and that leads to like their pain being disregarded. But these are things that need to be undone like at the point of training. But then also for the folks who are like already like out of their medical training, their ongoing training on like, essentially like on how to undo racism within the medical system. I think these are the things that are important. And I think actually they're the things that are more important than like litigation. I think this is something that comes through in the article, but something that I'm more convinced of in the intervening years is that like, the people who decide legal cases are just as susceptible to racist beliefs and to, to sexism and the things that lead to obstetric violence in the first place. And so we need to figure out like how to dismantle those, because it's like, trying to solve a problem with a tool that suffers the same shortcomings that like led to the problem in the first place is not likely to yield results. I mean, poor Renat Dre has been in litigation for like 7+, maybe 8 years now. I don't know. I feel like I've been working on her case my entire career, and it's not because it's like not a just and worthy cause. And I think, we're hopeful for what the appellate division is going to do, but like the court clearly does not know what to do with this situation. And like in the meantime, in the pendency of this case, the hospital has changed its policies due to a Department of Health inquiry, and there has been enormous public pressure, and there's been an entire campaign on human rights of pregnant people led by the New York City Department of Health. And also the New York City Commission on Human Rights is about to promulgate guidance on what it means to discriminate on the basis of pregnancy that incorporates her case, that sort of says that it is discrimination, it's prohibited, discrimination under New York City law to subject people to unwanted medical care on the basis of concern for a fetus. So like, there's been a lot of change in the culture, but also through other avenues where like litigation is really kind of a blunt tool that's not made for reconciliation. It's like really not made for culture change. It's meant for like kind of a very, very sort of slim view of behavior change. But like we don't just need change. Like change in behavior is important, but it's like not sufficient. So, yeah.
Thank you, Freya, and other folks. Feel free to raise your little hand.
Thank you so much for being with us today. One of our previous speakers in this series was speaking about the Equal Rights Amendment, and I was wondering if you've thought of the Equal Rights Amendment potentially as a tool for combating laws that criminalize abortion, or alternatively or complementarily securing abortion rights if Roe were to be overturned. So I was wondering if you've thought about it and if you could talk through some of the downsides or benefits of that as an approach.
Yes, it depends on what an Equal Rights Amendment says. And so, for example, we've been part of discussions about an Equal Rights Amendment in New York that would also include discriminating against a person on the basis of pregnancy or pregnancy outcomes. And I think that like the lawmakers have been very easily been able to seize on the idea of discrimination on the basis of pregnancy, because we have this sort of like robust case law and Pregnancy Discrimination Act and all these things that sort of let us think about discrimination against pregnant people in the workplace. But there's a lot of work that needs to be done in sort of like inculcating lawmakers into what the discrimination on the basis of pregnancy under the criminal law means, and that like it is in fact that it is discriminatory to single out one group of people. Like that, if only one group of people can do a crime like against their own fetus, right? Like if self-managed abortion is something that like only people capable of pregnancy can do, that is discriminatory. Like it is not. I think we were having to counter the argument that I described earlier, where prosecutors are saying, well, you can criminalize somebody for causing another person to miscarry. Why can't you criminalize the person for causing themselves to miscarry? And say like, no, that is a whole different thing. Like that actually like deprives that pregnant person of their rights. So it's kind of having to parse like what discrimination on the basis of sex means, and that it doesn't mean necessarily that like there are like equal outcomes, right? Like it is not equality to say that like everybody gets criminalized. It is equality to say like we support like people's self-determination of their reproductive lives, and that nobody gets criminalized for acts taken against their own bodies. Like that's what equality looks like. So, so I think we see a lot of promise, and we want to use those types of arguments. I think like, that's one of the things that we feel. I think there's probably a lot of people who are doing abortion rights work feel very hamstrung by, is the fact that like equality doctrine like hasn't been adequately woven into the sort of reproductive self-determination jurisprudence. Yeah, so we see opportunity, but also just like that hurdle of like that equality may not mean exactly like what you think it means. As like a first-year criminal law student, I feel like I've given talks to like dozens of like very kind of like early law school things, and there's always like one dude who's like, but isn't it equality if they get to be criminalized too? Because like and unfortunately like courts, there have been many cases across the states where criminal defendants have raised sort of the mirror image argument and say like, well, she had the right to end the pregnancy, so when I did an act of violence against her and it caused her to end the pregnancy, then like that's discrimination against me. Because she has the right to end the pregnancy and I don't, or whatever, and courts just do not find it convincing at all. Some of them are just like, it's different. It's not the same thing at all. So interesting line of cases.
Yeah. Well, that's what we might call sterile formalism, right?
Yes.
Lauren.
Hi, Farah. Thank you so much for speaking with us. I also found your presentation to be incredibly informative. My question for you is whether there is international law that may provide more protections for obstetric violence, whether it be via treaty or convention. I know the US isn't particularly deferential to international law, but I'm just wondering if there's anything that just may be more protective of domestic law that litigators may look to kind of inform their arguments.
Yeah. So that's actually precisely what we did in the amicus brief that we submitted in the Dohr case. So she had raised causes of action under the New York City and state human rights laws. And honestly, the New York City and state human rights laws are a little bit weak if you compare them to actual international human rights doctrine. But what we submitted our brief to do was to point out that there have been really leaps and bounds in recognition of the importance of respectful care at birth to people's experience and their exercise of their human rights. And I think in terms of what the actual laws say, it's not like there are specific laws, but in terms of practices or authoritative statements of law or observations by special rapporteurs, there in fact was a really recent report by the Special Rapporteur on Violence Against Women that looked specifically at childbirth and obstetric violence. And so, what we were doing was pointing to these things to say to the court, look, you have an obligation. We say it very, very softly. You have an obligation, but certainly you have a right to look at international law as a persuasive form of authority. Obviously, none of it is self-executing or binding in the United States. But if we're going to say that these laws are human rights laws, we should take a look at what actual human rights authorities say. And they speak very clearly that this is, these situations of abuse and coercion during childbirth are inappropriate. They discriminate on the basis of sex. They may rise to the level of cruel, inhuman, and degrading treatment. Right? It's pretty clear. So there is a lot out there, and I think that the United States is a little bit behind in some respects. I think the creation and implementation of laws to protect people during birth is something that that Latin America has really taken a lead on. But I think we've seen more recently the European Union looking at these issues in ways that the United States really hasn't. And in part, I think that there's a reticence. The medical profession is very powerful in the United States, obviously, as we saw, led to the criminalization of abortion. We're still, we're 50 years now almost of trying to undo this. But it's because I think it makes it very hard to have, meaningful policy discussions of the inappropriate ways in which people are treated and how that is a part of our crisis in maternal mortality and morbidity. So, that's not to say that it's totally a foregone conclusion. There definitely, I think, has been a lot of leadership, in particular of Black women OBGYNs, saying that there needs to be change within the system. And I think that we're finally getting to a point, I think, of listening, but it's taken just reaching this crisis point for the conversation to be a meaningful one.
I have another question for you, Farah. We've had an amazing trajectory around rights for lesbian and gay people from a decriminalization, where that actually got traction, I think, more than the decriminalization of abortion did. And then moved into a movement that could expand to other issues like marriage. And then we've got Bostock and the courts interpreting sex to include sexual orientation and gender identity. The abortion and reproductive justice movements have not seen that mobilization of Roe to the next step. And had it been kind of a spark of a movement, or although obviously it was already a movement, but it's been a right that's had to be defended and not enormously successfully. Why? But in some ways, they're very similar issues of sex and sexuality, bodily integrity, autonomy, histories of shame. I wonder why you think we've had a very different trajectory around lesbian and gay rights as opposed to the trajectory we've seen post-Roe with reproductive rights.
Yeah. So if I were to guess, I would say that there are two factors. One is that so one is sort of like the direct nexus of criminalization, right? So if you look at like Lawrence versus Texas, like the people who were doing the things are the one who are being criminalized. And so in a way, like that creates a greater urgency around decriminalization, where it's like the people who are being the people who are like making the decisions, engaging the behaviors and all that are the ones who are being criminalized. Like that question in terms of abortion rights has never been called like before the Supreme Court in the same way as, as LGBTQ rights. The other is kind of intertwined, but the fact that like abortion rights are mostly mediated through the providers. And I mean, I think that was a political calculation at the time of Roe, right? Like that, there's a lot of urgency coming from the medical community around the real harms that people were facing when they were, trying to end their pregnancies and ending up maimed or dying. And you can see that like in Blackmun's papers, right? That he was like very persuaded by like the opinions of the American Medical Association. And so like the fact that like the very first case, or like the case that sort of created the line of cases, was about like physicians and their ability to provide care. It sort of short-circuited the question. And so then it's like, I think that the question has been narrowed into like, how do people like, how do providers provide care and how do people receive care? Not the sort of bigger question of like people's ability to self-determine their reproductive lives, which is a much bigger question. And so, when I think about like, what are the sorts of legal theories that we would want to posit? I think that like Obergefell, like the sort of the liberty, dignity helix, I think that that's kind of like the like where we would see the arguments. And then also just like, frankly, I think we have been wanting to think about like, are there other novel legal theories like the Eighth Amendment, right? Like if we're saying that like some people may be criminalized for their exercise of an otherwise like of a constitutional right, like is that punishment that's like disproportionate, or the like, essentially there's like per se cruel and unusual punishment to criminally punish people for having ended their own pregnancies. And these are, like we have a lot of like not ready for prime time legal theories, but like I think that like we recognize that it's something that goes like way beyond the substantive due process analysis that we've been hemmed into, and like the sort of having gotten hemmed into some legal theories has cut off some really interesting things. Like I think one of the things that I used to think when I was a law student is like, well, why didn't anybody try to litigate First Amendment claims and say that like people have they can have a religious right to be able to access abortion, and like the just the Satanic Temple of Satan, which ones, the constitutional trolls one, have like tried to raise challenges to abortion restrictions, saying like adherents to our explicitly made up, explicitly atheistic religion have a right to access abortion immediately, and so making people wait 3 days to get their abortion is a violation of their First Amendment rights. And the courts are like, no, sorry, you get the undue burden. And like this is about abortion, so we're going to put it into this hole no matter what like arguments you try to raise. So I don't know. I mean, I think the sort of the distance that, even like we talk about the criminalization, people like say like criminalization of self-managed abortion, and I always say it's the criminalization of people who end their own pregnancies, because like the further the like issue is from the individual who's like having this thing happen to them, the easier it is to sort of make it into this abstraction. And maybe that, maybe that's where some of the distinction or like the difference in outcomes comes from.
Yeah.
That was a very freewheeling answer, sorry.
Well, I mean, it's a little bit of a law school question rather than a practice related question. But I do think there's something, a kind of dynamic in the U.S., other places, but particularly in the U.S. of social movements organized around identity, and and I'm purposely saying lesbian and gay because I don't think bi and trans have or queer have benefited as well as or as much as lesbian and gay people have. But part of it is it's been an identity-based movement that I think the reproductive rights movement has never maybe wanted to be or accomplished. And the law is able to kind of appreciate identity-based movements differently than, say, a health-based movement, which we don't have that for anything. Why would we have it for abortion, right? So, but I want to invite Rosario.
Farah. Thank you very much for being here. It was very interesting, your presentation. I have a question regarding these laws that protect these fetal harms laws. And I mean, it's a weird question, but I was thinking, is there actually any benefit for them when they don't criminalize the pregnant person? Like, for example, I'm just thinking, like, if a pregnant person loses her pregnancy because she is beaten up, should there be a specific crime for that? Or should there be a specific, I don't know, aggravated type of crime for that? Or should we try to avoid this altogether because it would be giving a special protection to the fetus that might, in the end, be bad for abortion rights, for example?
Yeah, yes. So definitely the latter. I think that it's something that ultimately does more harm than good. And not just because of abortion rights, but just because of the possibility that people are criminalized for their outcomes or the circumstances of their pregnancy or things that they do or don't do during pregnancy. Certainly, like in the scope of cases that I've worked on, it's really been a minority in which it's people who are charged with a crime for abortion. And it's more like people who use criminalized drugs, people who are in a car accident, you know, all these sorts of things. It's sort of the sequelae of those types of laws. And I think, you know, in terms of like, what is our response to injurious conduct towards pregnant people? So like the first thing is, unfortunately, you know, none of these laws have had the effect as they were intended to have, right? Like, I think one of the reasons that these laws are often offered is, you know, supposedly to protect pregnant people from intimate partner violence, because certainly, like, it is factually the case that pregnant people are more susceptible to intimate partner violence. It's a moment of vulnerability that abusers will, you know, take control of. But in states that have passed these laws, there hasn't been any attendant decrease in violence against pregnant people. So like they're not having the benefits that they're intended to. And then also we have other ways that we can address harm to pregnant people. Like we already have a lot of criminal laws. And so, you know, one case that is sort of like the nightmare scenario that arose in Colorado, a woman was pregnant and was lured to a house. Like somebody said they were selling some baby clothes. And so this woman went to the house in the Craigslist ad, and the person who was there attacked her and actually cut the baby out of her uterus, right? Like left her for dead. It was like horrifically violent crime. The woman survived. Unfortunately, the baby didn't survive. And so there was a lot of public pressure to create a new law. Like Colorado doesn't have an Unborn Victims of Violence law. What they have instead is a Protection of Pregnant Women Act that criminalizes unconsent, like ending somebody else's pregnancy without their consent. And it explicitly says this doesn't create any legal status for the fetus. Fetuses are not considered persons. Like this cannot be used to criminalize a pregnant person. So, you know, like whether or not we even need an additional criminal law like that, I think like is a question on which reasonable minds can differ. But the person, you know, who committed this horrific act of violence and like, you know, created all this trauma, even in the absence of an Unborn Victims of Violence law, was facing like 285 years in prison. You know, I think that there are a lot of like legitimate questions about the utility of like our carceral system and all that we'll leave to other people in other lectures. But you know, the idea that we need to penalize somebody beyond 285 years, like, I wonder why, like, that's, you know, and I think like that's been a critique that's come up here in New York with the repeal of the criminal abortion law and the criminal self-abortion law. You know, we've seen abortion opponents say like, oh, well, now there's no way to criminally punish people for acts of violence or harm to pregnant people. And that's simply not true. Like, one, New York's abortion laws were never authorized to be used that way. And like there's case law that explicitly says that like if you hit a pregnant person with your car, that's not an illegal abortion. Like it's not, you can't use the law that way. It's intended for an abortional act, not an act against the pregnant person. And like, you know, certainly like like New York, I don't think has shied away from prosecuting people who've done harm to pregnant people. And, you know, even without an Unborn Victims of Violence law. So they're not necessary, they're not helpful, and they're ultimately harmful. There's just like there's no utility to them.
So Farah, do you have any advice for law students of things that they could be doing in law school in order to launch a fabulous career like yours?
You know, I don't know. It's hard. I feel like I fell into it backwards. I think that it's, you know, like if you're interested in reproductive justice, just keep being interested in reproductive justice, right? Like participate in your If, When, How. There are a variety of fellowships that might be a good thing to do out of law school, including the If When How Fellowship. I think we offer, oh gosh, this is not my department, so I'm going to completely misconstrue it. I urge you to go to our website to read more about it, but we have several different internships for recent law grads and new attorneys to be placed in organizations that are doing reproductive justice work. And some of them are more like DC, like policy, law and policy shops, but some of them are like state-based placements, in Tennessee and Washington State, whatever, doing like specifically state-based work in service of reproductive justice. So definitely, like, if it's something you're interested, look into those. And I would love to like answer folks' questions. Like, if you ever like have any questions, please feel free to contact me. I want to, I want people to feel like they can do reproductive justice work. They can serve reproductive justice wherever they are. And I think like the biggest piece of advice I have to give folks is like to just think very broadly about what it means to be doing reproductive justice work. I noticed that in this speaker series, Lisa Sangoy, good friend, former colleague, spoke to y'all looking at like family defense work as like the front lines of reproductive justice work. I think people, sometimes overlook that as an area of practice that like is reproductive justice. And then also like if it turns out that like abortion rights work isn't exactly your like cup of tea or the thing that you want to build your career on, that you can bring a reproductive justice perspective to everything that you do. And so like a lot of my close friends and colleagues are like, practice in like landlord tenant law, like, and they bring to it this a reproductive justice perspective. And also just keep in touch with If When How, because we're always looking for ways to connect folks to the movement, whether that's like, with research projects or criminal defense cases. Let's hope that there is little need for that, but there definitely there is a lot of room to plug in and serve reproductive justice kind of wherever you are, whatever your practice looks like.
And there are opportunities for students to be interns during the school year and the summer, besides the fabulous fellowships after their graduation?
We're still working on that. So as an organization that's been in a lot of flux with the merger and being an all remote office, we're still figuring out what our internship program is going to look like. But when that happens, we'll definitely, my being here in New York City, we'll definitely post with all the local career offices and stuff like that. So, so when there are opportunities, you will definitely know about them.
That's wonderful. That's wonderful. And for those of you who are interested in this range of issues that Farah's been talking about, Professor Sanger also teaches a class that's that touches on so much of these issues. So make sure you find your way to her. Farah, thank you so much for joining us. It was really wonderful to hear about the work, how challenging the work is, but that there's a vision of where we're going. We're not just on defense, we're on offense too. And it's hard to maintain both those valences, I think, at times, because there's so much coming our way that's rights denying. But thank you for the vision you have of the work and why we should be doing it. So have a safe evening. Thanks so much for being here.
Thanks, y'all. It was really a pleasure.
So